Hey guys, welcome back to another video. Today I'm going to be discussing how you can ask the court for help if you're not having regular contact with your children, or perhaps you and your ex have fallen out so much that you're not seeing your children at all. The types of applications that you can make to the court and the types of orders that the court will give you. And remember, if you like this video, please like and subscribe. For those of you who don't know who I am, I'm the Legal Queen, a family law solicitor. I've been practicing family law now for in excess of 20 years. So let's talk about ways that the court can help you if you're not being allowed to see your children. So what we call this group of orders, if you like, are child arrangements orders. Now that is an umbrella term for all types of orders that the court can make in respect of children. So typically, I get asked this question all the time, what kind of order do I need? That will depend on the problem that exists within your family unit. And remember, these orders apply to everybody as opposed to a married couple or an unmarried couple. It really doesn't matter. As long as you have children together, you have parental responsibility for those children, you can apply for a child arrangements order. On that point of parental responsibility, if you're a father watching this video and you don't have PR, that's how we refer to parental responsibility, don't worry too much about that. If you are the biological father and you're not named on the birth certificate, or you weren't married to mom at the time the child was born, you may not have PR, but that's okay. When you apply for your order, by virtue of getting that order, the court will grant you PR. All it means is that when you're filling out the form, just let the court know that you don't automatically have the parental responsibility and you are looking to get that as well as part of that order. So let's give some thought to what kind of orders the court can make. The first one is our typical child arrangements order, okay? So it will determine who the children live with and how much contact or time they spend with the other parent. Sometimes it will be a shared care arrangement. So typically the children will share their time between each parent. Or sometimes it's a live with order. So the child will live with mom for these days in the week and live with dad for these days in the week. Another order that you can ask the court for is what we call a specific issues order. That's where you want something to happen. Let's say that you want your child to attend a specific school, or perhaps you would like your child to have some sort of medical treatment and the other parent simply isn't in agreement with you. You're going to apply for a specific issues order that the court grant you permission for the child to do whatever it is that you want them to do, such as attend that school or have that medical operation, if that's the case. Another order that we can ask the court to give us is what's called a prohibited steps order. This is the opposite to a specific issues order. This is where we want to stop the other parent from doing something. Perhaps we're concerned that the other parent's going to attend at the child's school or nursery and remove the child from that school or nursery. If you don't want that to happen, you'd ask the court for what we call a prohibited steps order, so that it prohibits or stops the other parent from doing that, from removing the child from the school or the nursery, or even from your care without your agreement or without further order of the court. So now that we know the kind of orders we can ask the court for, how do we go about applying for them? Well, typically it's the C100 form. So if you have a look at the C100 form, which you can download from the government website, and I'll put the link below, you'll be able to see on the front page, it's actually saying, what do you want from the court? Do you want a child arrangements order? Do you want a specific issues order? Do you want a prohibited steps order? The rest of the form is then really admin. So it will be asking for your details, name, address, the other parent's details, their name and address, where the children live, the children's full names, their dates of births. It will also want to know if anybody else has parental responsibility. Sometimes where we have step parents involved in the family dynamic, then a step parent might have parental responsibility. So anyone else that has PR must be named on the form. And then it will ask you for just a brief outline, just to give the courts a heads up on what it is that you're asking the court for. Are you asking them for a child arrangements order? And why are you asking them for that? Is it because you and the other parent can't agree on how often you see the children? Or perhaps you can't agree on overnight contact, for example. The other thing that you'll see on the C100 form is some information that it requests from you about a mediator. So prior to submitting your C100 form to the court want to know if you've at least attempted mediation. Now remember, mediation isn't compulsory, it's a voluntary process. So the court's not forcing you to go to mediation, but it wants you to consider mediation. So what does that mean in reality? Well, what it means is that if you want to submit your C100, you're going to have to reach out to a mediator. You're going to have to tell them that you've got no agreement between you and the other parent as to how you're going to see the children, and that potentially you might be looking at making a court application. Now the mediator will take it from there. She's going to assess if the situation is suitable for mediation. If it isn't, she's going to give you what's called a MIAMS form, and that's the form that you need to attach to your C100. If she thinks that mediation might assist, she'll let you know, and she will reach out to the other parent on your behalf and see if they're willing to consider mediation. So when you see that in the C100 form, you might need to take a break from filling it out, pause for a moment, and then go and speak to a mediator, because without that MIAMS form, you're not going to be able to submit your C100. Unless, of course, you've got an exemption. So some of the exemptions, just to give you some examples, are perhaps one of the parents lives overseas. Perhaps one of the parents is maybe unable to attend mediation for medical reasons or whatever, other reason that might be. Perhaps one of the parents is in prison and is unable to attend mediation. There might be an urgency to your application, and that's why you haven't got time to contact a mediator. Or it might be that there's domestic violence involved and therefore mediation isn't appropriate. So there will be a list of exemptions. Have a read through those and see if any of those apply to you. If they do apply to you, tick the box. You then don't need to see a mediator. So your C100 is all filled out. You're going to email that into the court. Now it's going to be the family court nearest to where the child lives, okay? And the reason for that is because later on down the line, the court might feel that CAFCAS is an appropriate person to be joined to these proceedings. And I'll talk about CAFCAS in a moment. And of course, it'll be the CAFCAS officer that can attend court and that can also see the children. So you're going to want to have the court nearest to where the children live. A court fee is going to apply of £232. When you submit your form, the court generally will then give you a call the next day or perhaps the same day and take that payment from you. If you are on a low income or in receipt of benefits, you may qualify for what's called a fee remission. What this means is that you can be eligible for maybe a discount on that court fee, or perhaps you don't have to pay the court fee at all. How you find out if you're qualified for fee remission is by filling out the EX160. Fill that out, send it into court. If the court find that you are eligible, they will give you what's called a help with fees number, HWF number, and you'll put that number on the front page of your C100. And that means you don't have to pay the £232. So CAFCAS are the court's own social workers. They will deal with families that are in the court system, so involved in the litigation. And what they help the court with is to give a third-party perspective, that unbiased view, if you will. So obviously, mum's going to have a position, dad's going to have a position, but the court want to see what's in the best interest of the child from somebody that's not emotionally involved in the case. And of course, remember, the Children's Act, which is the piece of legislation or the piece of law under which all these orders are made, says very clearly that it's the child's right to have a relationship with both parents. So it's not the parents' right that they have a relationship with the children, but the child's right. So CAFCAS will assist the court by perhaps speaking to mum and dad separately, speaking to the children, obviously depending on what age they are, and then feeding back to the court what CAFCAS consider to be in the best interest of the child. So what to expect? You've filed your C100. You have received a hearing date from the court. What to expect at that first appointment? Well, at the first appointment, you're simply going to attend court and let the court know what you need help with, what type of order you need and why. Of course, the other parent will also be present in court, and they're going to tell the court why they don't agree with you. And from there, the court will then make directions. Those directions could be a multitude of things. It might be that the court want both of you to write statements. In other words, get down your view in writing so we can submit that as evidence to the court. It might be that the court at that point think it's appropriate to get CAFCAS involved so that they can do what we call a wishes and feelings report and give some feedback to the court on what's in the best interest of the children. So guys, I'm going to wrap that up there. I could honestly talk about this topic all day long. It's such a large area of family law, and one that we are always being asked about, because obviously having a relationship with your children is ultimately one of the most important things that parents strive to do. I hope you enjoyed that video. Don't forget to like and subscribe. Leave any comments in the section below, and I look forward to seeing you guys next Wednesday at 7 o'clock for another family law video.